Hey everybody, it's Yasha Saba from Sky Unlimited Legal Advisory, a personal family lawyer helping clients keep their family and loved ones out of court. This is our Ask Me Anything, so you can email your questions to me confidentially and I'll answer them openly in public so that we can inform the world. If any of you think in your questions have any kind of confidential information that kind of gives away who you are, I'm not going to answer them. Instead, we'll do something more privately. In the meantime, I'm on the road again. Just got out of a client meeting and now I'm leaving San Francisco to go to San Jose to give a presentation later today. But for now, let's answer some questions. All right. First question, what is the best action to do? The father of my children bought a piece of property, piece of real estate in cash and passed away without doing any will. That's going to hurt. So we were never married, but we have 2 children together. He has other kids from 2 different women. So we're in a blended family, is what you're telling me. And one of the kids from the other marriage never allowed the father to see his child, but is claiming money now. All right. So there's a few key points going here. First, you and the father of your children were never married. So there's no community property whatsoever. You are 2 separate individuals. So what does that mean? When somebody dies and they have real estate, especially real estate, and they don't have a will, that property has to go through probate. And the way the law works here in California is if you're unmarried, the partner, significant other, doesn't get anything. You get nothing out of probate. Everything will go to the kids. If any of the kids are under the age of 18, they cannot legally inherit. They're going to have to inherit through a court-created trust, which is what we call a testamentary trust. You may be able to become the trustee of that or the judge, depending on the circumstances and how contentious it gets between all the kids in court, may appoint a court-appointed attorney to manage that trust and manage that asset. Nevertheless, there are 4 kids that this father had, and all 4, each one of them are going to basically acquire this property individually. Hopefully it's rental property and not your primary residence, because that can get a little ugly. What might end up happening is the judge might just say, all right, we're just going to sell the property and divide the cash evenly amongst the kids because it's too complicated to have it divided. But if all the kids come together and they say to the judge, no, we want to keep the property, that'll be great. Just based on what you said from your question, the fact that children from another marriage are preventing father from seeing his current kids, your kids, I think there's a little bit of contention there. I would just advocate to send the property through probate, have it sold and split the cash evenly so that everybody leaves happy. But yeah, that's most certainly going to end up in probate. There's really not much you can do there. I suggest you get your estate plan done because you have children and it sounds like one of them might be a minor. All right, next question. Are there options for transferring retirement accounts to heirs? But there are no designated beneficiaries on the accounts? Okay, you have your retirement account, you don't have beneficiaries named, and you want to know if you can just transfer the account over to your heirs. First, retirement accounts cannot be transferred. This is not like a regular bank account where you can retitle it, add someone's name on, add others. It's because there's a lot of legal regulations around the tax implications of the retirement account. Whether you have a 401k or an IRA, there's tax implications on what happens to the account when you start pulling funds from it. And then if you have a Roth 401k or a Roth IRA, there's tax implications of when you put money into it and what do you want to have happen to that next. Legally, no one else but you can own these accounts. In order to transfer it to someone else, you're basically, you can not transfer the account, but you can pull the money out, pay your penalties to the government, whatever those may be, and then you can take that money and transfer it to someone else. But realistically, you need to name beneficiaries. This is how we transfer these retirement accounts to your heirs after your death, is they then become the beneficiary of the account. They're not the owners. The retirement account is still in your name. What might end up happening is the bank might create a new account, like a trust account for that IRA, or a beneficiary account where the money is in the same IRA. It's just now it's clear that the beneficiary is someone other than you. It's somebody else. So the bank is holding that IRA account on behalf of your heirs, whoever you might name. But yeah, you need to name beneficiaries on your accounts. They cannot be transferred, and a trust can't even own the accounts. We usually name a trust as the beneficiary and then allow the trustee to handle the assets from there. So there's a little bit more control. I have inherited stocks and bonds given to me, but can't cash them out. I'd like to pay my debts, small debts, buy a house, and create an estate plan. I'm 25 years old. Can you tell me the legal steps to take? Okay, so there's not enough information for me to give for you here. You have stocks and bonds. Ideally, you can sell your stocks and bonds, pay whatever capital gains taxes you have, and then go buy whatever assets you want to. The fact that you can't cash them out suggests to me that there are restrictions in place. Maybe you don't actually have the stocks. Instead, what you have is a stock option, which suggests that you're working for a company. They give you a contract that says, as long as you're working with us full time or whatever, we're going to give you this many shares. So we're putting aside these shares just for you. These are called unvested stock. And then as you work with us on certain milestones, a certain amount of stock will start to vest. When your stock is vested is when you have the option to sell them. However, if you're working for a startup or a non-public company, you might even be restricted from selling your stock then, because when it's not public, the federal government has restrictions, the state government too has restrictions and laws on how you can sell those assets. But you most certainly can sell those assets. That is absolutely for sure. It's just not as easy as putting it on E-Trade or a Charles Schwab brokerage account and then selling it on the open market. Same thing with your bonds. A bond is like a note from a company or a government agency that's given to you. You give them money and they're going to give you an interest rate in return. And then that bond is registered as a bond, not just a loan. And that means you can sell that bond to anyone and there's a value there. I don't know what the restrictions are. If you want, you can submit your question to me again. Let me know what restrictions there may be, but there shouldn't be any other reason if they're all vested and there's no restrictions from trade on them, like it's all from like a public company, for instance. You can work with your financial advisor to actually go ahead and sell those assets and then use the cash to do whatever it is you need to do to take care of your life. Okay? All right, everybody. This is Yasha Salvan from Sky Unlimited Legal Advisory. As always, if you have questions, send them to info@skyunlimited.law, or you can just give us a call at 650-761-0992, and we'll take your question message to say, I have a message for the Ask Me Anything, and we'll answer them. All right? Take care. Bye-bye.